my name is Brad Dixon. I'm a trial lawyer, and today I want to talk to you about separation boards in the Army. For an enlisted member, if you're notified that the Army plans to separate you for an other than honorable discharge, or if you have more than 6 years of service already under your belt, you're entitled to a separation board. Now, if the Army notifies you that they plan to seek a general discharge or an honorable discharge, you're not necessarily entitled to that board unless you have 6 years of service already under your belt. If you're an officer, generally speaking, you're just automatically entitled to a board unless you're in probationary status. So at these boards, it's essentially like a trial. You have 3 members of the board, and it's normally held in a conference room. There are your defense attorney, which could be TDS, or if you hire an attorney, you can have them there as well. And there's usually a trial counsel there, and the trial counsel is a captain normally, and they act as the prosecutor. Everybody sits at this conference table, and the prosecutor lays out the facts of the case through documents or other evidence and calls witnesses. You also have the opportunity to call witnesses, and you have the opportunity to cross-examine the government's witnesses. And once you're done calling all the witnesses, you get to make a closing argument. So it works a whole lot like a normal trial that you would see in a criminal matter or a civil matter, except this isn't a criminal case. It's an administrative case where the Army is trying to fire a person. Now, at the board, the members have a few decisions to make. The first decision is whether, by preponderance of the evidence, they believe that the respondent, or the person who's being kicked out, committed the alleged misconduct. And if they find that, then the second determination is whether that misconduct warrants being separated from the Army at all. And if they reach those 2 decisions, then they go to the third decision, which is what characterization of discharge does the board recommend? Now, whatever the board recommends with regard to whether a separation is warranted at all or what kind of discharge to recommend, that binds the hands of the commanding general and ultimately HRC with respect to whether they can discharge a person and what kind of characterization they can give. So, for example, if a soldier goes to a board and the board votes to retain that soldier, it's the end of the game. There's no way that the commanding general or HRC could take any harsher action against them, so that they're just simply not discharged. If the board votes to give a general discharge, then there's no way that the commanding general or HRC could give any harsher discharge, like other than honorable discharge. Now, it's impossible to get a discharge harsher than an other than honorable discharge, because the only 2 that are worse than an OTH is a bad conduct discharge and a dishonorable discharge, and those can only be given at a court-martial. If you're facing a separation board, whether you're enlisted or whether you're an officer, and you have questions about how it works, or you need representation at the board in an effort to tell your story, give me a call.